All right, welcome everyone to the final meeting of the Joint Judiciary Committee. We've got a good busy agenda for today and tomorrow. Thank you for making time to join us and to participate. We will follow the agenda as it's outlined. We'll be taking, if you looked at it, plan is to take action on interim topics, the bill topics tomorrow. We'll work through the process today and get information and kind of flesh this out a little bit. But as far as hard votes, the intention is to get to that tomorrow. I don't believe we'll.
No, we have some today.
We have some today.
The judiciary.
But anyway, if you'll address your comments to the chair, and we'll just work through this as we go along. We want to welcome Justice Fox. Thank you for joining us today, and Judge Day and Tyler and Blumel, and Commissioner Henry. I think we've got everyone, and it's here. It's going to be it'll be a good day. And with that, Tori.
Take a roll call. Senator Anselmi Dalton.
Here.
Senator Hicks.
Here.
Senator Kinski.
Here.
Senator Nethercott.
Here.
Representative Beitman.
Here.
Representative Jennings.
Here.
Representative Olson. Representative Pelkey.
Here.
Representative Pinnell.
Here.
Representative Salazar.
Here.
Representative Stith.
Here.
Representative Winters. Here. Co-Chairman Kirkbride.
Here.
Co-Chairman Christensen.
Here.
A quorum. Senator, Mr. Chairman, I'd also just point out that we are live streaming with video, so that both the audience and the committee is aware of that. If you have a private conversation, make sure that you're away from the microphone and that your microphone is turned off. You press the button, the red comes on, and that should broadcast your voice. Please do press the button so that we can all hear and that the video will broadcast that across the state. With that, Mr. Chairman, I think that the next agenda item is the approval of the September minutes.
All right. And with that, on the September minutes, everybody had a chance to look at them. We have a motion on the September minutes.
So moved.
We have a motion, Senator Kinski, Representative Pelkey seconded on that. Any discussion, changes, corrections on the September minutes? With that, all in favor, say aye.
Aye.
Any opposed? Thank you. All right, on to guardianship. Tori.
Mr. Chairman, I'm going to hand that over to Staff Attorney Brian Fuller. But before I do, I should introduce the folks at this table. Kyla Spencer is a staff attorney. She'll be participating later this morning in some of the bill discussion or introduction. To my left is Mary Beth Oatsvall, staff with LSO. If you have questions about any of the hard copies, please see her. She's our expert on making this meeting work smoothly. I'm Tori Racinas, and turn it over to Brian Fuller.
Brian.
Mr. Chairman, good morning. Brian Fuller, Legislative Service Office. Just by way of overview to recap where the committee's been, the committee has considered this issue of guardianship and de facto custody at both prior meetings this year and at its final meeting of the last interim. At the last meeting, the committee heard from two speakers who focused on the best interests of the child and the child's attachment to the guardian. The committee reviewed 19 LSO 26 version 0.5. That's 201 in your binders. This bill draft would allow courts to consider various factors when a parent moves to terminate a guardianship. The bill draft would also allow courts to enter various orders related to the termination of that guardianship. In addition, Mr. Chairman, in your materials, 2-02 is a memo I prepared. A lot of this information should be familiar. It repeats what I've discussed in previous memos in terms of an overview of U.S. Supreme Court precedent on guardianship, on parental rights, as well as the Wyoming Supreme Court's interpretation of our guardianship statutes. The language provides that the court may appoint a guardian if the allegations of the petition as to the status of the proposed ward and the necessity for the appointment of a guardian are proved by a preponderance of the evidence, and the court has held that the Supreme Court has held that a district court can only appoint a guardian upon a finding of necessity, which the court has interpreted based on U.S. Supreme Court case Troxel to mean that a parent is unfit. Mr. Chairman, I'll direct your attention in the memo to page 5. I have expanded a bit on the Supreme Court's discussion in a case, Enri SRBM, to provide an outline of requirements that would need to be followed for the termination of a guardianship. If a parent seeks to terminate a guardianship, she must prove that the guardianship is no longer necessary. The court has suggested that if a parent was found unfit, that the parent must prove that she is fit, or otherwise the parent must prove that, must establish that the guardianship was no longer necessary for the reasons that had been established. And then if a fit parent does establish that a guardianship is no longer necessary, the parent would be presumed to be the child's guardian, and the guardian must then rebut that presumption. Mr. Chairman, beginning on page 6 is information from other states regarding their a broad survey of other states' guardianship statutes and how their courts have interpreted those statutes in light of Troxel, among other things. And I think, just to kind of cap that, each state views guardianship in a different way in terms of, is the focus more on the children or the parents? But that information, Mr. Chairman, I'm happy to go into further detail. But suffice to say, I think it's up to this committee to decide, how in terms of considering this bill draft, what interests it chooses to put forward. One more thing about the bill draft, Mr. Chairman. It is unchanged from the last meeting. So this bill draft that's before you is identical to the one the committee considered at this last meeting.
Okay. Committee, any questions of staff at this point? What I intend to do is work through the agencies and public comment, and we'll come back to the committee. But
Chairman,
so far, Senator Kinski.
I wonder if Mr. Fuller might give comment on it's an excellent memo, by the way, and thank you to staff and to Mr. Fuller for that. It's very well done. And I agree with the framework that he outlines on page 5. I think it's not only what the Wyoming Supreme Court would require, but I think it's what the U.S. Supreme Court would require. He does highlight that there is, going a little bit out on a limb to suggest that we might change the presumption one way or the other. But I wonder if he might offer comment on the framework that he outlines on page 5 and how that is or is not reflected in the bill that we have before us, the 0.5 version of the bill.
Okay, Brian.
Mr. Chairman, Senator Kinski, I would first direct the committee to page 4, lines 10 to 13, subsection B of the newly created 331107. And this provides that the court may consider the factors in subsection A, which are various factors related to the parent's situation as well as the child's. But it provides that the court could consider those factors without first making a finding of parental fitness or a finding that the guardianship is no longer necessary. I think that, Mr. Chairman, that subsection could, exist within that framework. I think ultimately it's a question of policy, though, for the committee to decide how it wants to approach that.
Senator, oh, Tori? Oh, they're chatting. Senator Kinski, does that answer your?
No, Mr. Chairman.
And Mr. Chairman, the other point I guess I would raise is in subsection A, and maybe this would get more, I think this would more directly implicate this framework that I've outlined on page 5. But on page 2, lines 1 and 2, the bill draft provides that the court would consider these factors upon the filing of a petition for termination of a guardianship by a parent. And Mr. Chairman, one suggestion I could offer to tie in this standard, this discussion from Henry SRBM, is to make clear that the factors would be considered upon the filing of a petition for termination of a guardianship by a parent who has been adjudicated unfit. I think the committee may want to consider doing that insofar as it would bring in this question of unfit and would allow those factors to be considered, as part of that question of fitness.
Okay. Any
So,
other questions? Yes, Senator Kinski, follow up.
So thank you for that, because, and again, this would be for Mr. Fuller, for Mr. Racina's, on lines 2 and 3 of page 2, the lead off is consider the best interest of the child without first having a threshold determination of fitness or unfitness. The balance of the factors seem to make it a horse race as to who's got the better home, the guardian or the natural parent, and that's not the test. I mean, if that parent meets that constitutional threshold of fitness, they may not be the best parent compared to the guardian, but they're still the parent, and they have the right to that child. So in my view, I guess I'm seeing this. I like the idea of a two-prong approach. First, let's look at the situation where the parent's been found unfit, and now the judge is taking a hard look at whether dad has really overcome his drug and alcohol issue or whether this is just a brief rebound, as opposed to the other situation where dad or mom voluntarily relinquished. There wasn't a lack of fitness, and I don't think the bill gets us there. And I may be missing something, but I just wonder if staff could tell us whether they really are seeing that framework of page 5 of the Fuller memo incorporated into this bill clearly.
And anything else at this point from staff? One of the things we can do is we work through the conversation with both agencies and the public. Some of these questions may either be highlighted or answered. And then we come back around with committee discussion also. But at this point, Brian or Tori, anything you want to add relative to that at the moment? Senator Kinski?
Mr. Chairman, I guess the only thing that I would add to address Senator Kinski's point, and that is well taken, and that's been the struggle with formulating the bill and the memos. We have disparate interpretations of the impact of Troxel across the states. Wyoming's current law is based on the existing guardianship statute and the term necessity. The legislature in the first instance has the ability to change the statutory framework for guardianship. This is an attempt to do that. Clearly, whatever the legislature does, takes its first stab at the constitutionality, passing a constitutional bill, could be subject to review under SRB and under the framework that the Wyoming Supreme Court has determined that those cases under Troxel. So I think that it's important to understand that the statutory framework is the starting point for those MEO and SRB cases. Changing the statutory framework may or may not change the outcome from the Wyoming Supreme Court. And we're not in a position to make that prediction. I think Mr. Fuller's suggestion of in lines 2 and 3 on page 2, placing the adjudication of unfitness helps that question because you then start from the position where a parent has been adjudicated unfit. But all that being said, that this is all information for the committee to make a policy determination and make that determination about constitutionality in the first instance, which, as Brian's memo points out, first lies with the legislature, then the governor, and then, of course, the courts.
Thank you. Senator Nethercutt, anything at the moment? All right, any other questions of staff so far? All right, with that, let's open this up to input, and we'll start with our agencies. Offer the first round if you'd like to at this point to the judiciary. Like you're on your own, Judge Day. Oh, could you pull the mic over in front of you and make sure the little button is slightly tapped so the red light comes on? There, or move over near the mic.
There we go.
Thank you. All
right. Tim Day from District Court in the 9th Judicial District in Jackson. We don't have any uniform position from the district courts on this particular issue. And I know this was discussed last time and I had to leave early, and I think maybe Lily might have offered some of my comments just based on a recent case. And all I can do is mention that as kind of the practical situation that sometimes district judges are faced with in these kinds of situations where you might find, grandparents have raised the child since almost birth. They've been for several years basically the child's parents. The child's parent or parents come back and ask that the guardianship be terminated because it was established because they weren't capable of taking care of the child originally. And so you go through this analysis that we currently have in Wyoming and see if the parent is fit or unfit. And then you move on to whether it's still in the best interest of the child to have the guardianship, whether the original purposes of the guardianship are no longer necessary. And what you can do is find yourself in that situation where maybe you have a marginally fit parent, and based on the original reason for the guardianship, it's probably not there anymore because the parent is marginally fit. But you hear expert testimony from teachers, counselors at school, counselors for the child, who talk about the attachment that they have to the guardian and maybe the special needs that they have, and how it would be seriously detrimental to the child's best interest to just send the child back to mom or the parents. And there's a little bit of a limbo, I think, in the current state of the law as to, what power the or what we can do in terms of fashioning a transition plan for the child, and how long we can design that transition plan and how many conditions we can put on it. And there have been a couple cases in Wyoming where district courts have attempted to do that, and sometimes it's okay, and sometimes, in one case I can think of in particular, it wasn't, because it wasn't definite enough, and so obviously this bill would kind of address, again, not starting with the fitness of the parent, but what's in the best interest of the child. And of course, wouldn't be prepared to opine on the constitutionality of that, but it does. The current situation does leave us, I think, sometimes in the dilemma of this. Maybe this isn't maybe the best parent, but it's a fit parent, and maybe it's not in the best interest of the child, but do the parental rights trump that? Just a practical example of how sometimes we see this come down in courts and how this kind of legislation might affect that.
Okay. Senator Hicks.
Yeah, Judge Day, you used a terminology that brought in a new concept that we hadn't, the committee hasn't discussed, and that's you used the word marginal fitness. So I'm just curious, is from your perspective, is there a distinction or some way we can delineate between what somebody is marginally fit or the definition of fitness as it applies to the court rulings that we have?
Please.
Well, legally, I suppose you've got to make that decision, are they fit or not? And then practically speaking, we all know that there is a broad spectrum of fitness of a parent. And so the tougher cases are where I think, speaking for myself, you're sitting there and you're going, well, I think I'm going to have to find that this parent is fit, but it's just, they're just over the line. And it may not be in the best interest of the child, especially after I've heard this testimony, but I really don't have any choice. So now I've got to figure out how to transition the child back to the parent's home and do the least amount of damage to the child.
Follow up?
Yes, Senator Hicks.
Mr. Chairman, so taking that to the logical next step, the way that the bill's drafted, and we all agree on the concept of marginally fitness. We know what you're describing, and we're trying to thread the needle here. So the way the bill's drafted, it brings in the concept that the determination of the best interest of the child. Does that help you from the judicial side get to this issue of marginally fit? Does that now modify the ability to make a strict ruling on fitness? Because now fitness is modified by the preposition that first we have to look at the best interest in the child. So does this now give you different degrees, whether it's marginally fit, superiorly fitness, or whatever it goes, because we changed that concept now that you have to go through the best interest of the child? Does that help in those determinations? I guess the question is does that help provide the discretionary ability for the judiciary by bringing in the concept of marginally fit when we say it has to be in the best interest of the child?
Please.
Good question. I don't really know the answer to that. I don't know if that would be, if that still raises constitutional concerns that you're not focusing first on fitness as a parent, and as you suggest, you're deciding fitness based on what's in the best interest of the child and how those two fit together. So I'm not sure I could answer that. I think it's certainly, those are factors. A lot of those factors that are set out in this draft bill are the same factors that we look at in determining custody for children, statutory factors that we consider in determining custody of children, looking at the best interests of the child, which is what we need to do.
Okay. Yes, Representative.
Mr. Chairman, thank you. Judge Day, I got a question that currently the way the system works now, and we've heard the horror stories over the past couple of years on some of these instances that have taken place with children, with their grandparents, and the parents coming back wanting to take custody. And I guess my question is, currently, the way the law sets now, if they come in and ask for removal of the guardianship, and there's a history of criminal activity, a history of drug abuse, do you take that into consideration now? And with this bill, would this give you more leverage, I guess, is what I'm trying to figure out with the current law and what this bill would do, if it would, because the bottom line is these parents that we're trying to deal with, I think, is the ones that are definitely unfit, the ones that have a lengthy criminal history, have a drug history, and continue down that line. I just want to know if the current law is, if you can address that, or if this bill assists in that.
Judge Day. If at any point any of the other judges would like to come up and
Yeah,
support your,
I think the question that I have in looking at this is, does this how does this relate to the standard that we previously worked under to say, okay, does the reason for that the guardianship was originally established still exist, and if it doesn't, is this a fit parent? Then child goes to parent. All of a sudden, this says, okay, balance these best interest factors, but it doesn't talk about how this relates to fitness of a parent and how you assess that. And I didn't see where that explicitly really addresses that. And that goes back to the question that Brian's raised about, would this be a constitutional bill or not?
Senator Nethercott.
Thank you. Thank you, Judge Day. One piece that I want to draw the committee's attention to, and perhaps Judge Day, is that this bill focuses on the back end of a guardianship when a guardianship is being terminated, not when a guardianship is being established. So is it fair to say that when a guardianship is being established on an involuntary basis and someone is trying to prove that a parent is unfit, can you explain to the committee what factors the court usually considers in making that determination of unfitness like you're currently doing now?
I think, and I'd invite my colleagues to jump in here too, but I mean, I think it's basically, it's best interest of the child, that it's important for the welfare of the child. And so you're considering some of those factors.
Mr. Chairman?
Yes, continue.
Judge Day, in establishing a guardianship, is there any statutory requirement that best interest actually be analyzed by the court, or is it solely on fitness or the fitness of the parent?
Judge Day.
See if my colleagues have any. Joe?
And if you could just make sure that mic's turned on too. Thank you.
Mr. Chairman, thank you. To try to answer your question, Senator Nethercott, I hate to do this, but I almost want to go the next step and say, seldom do I actually have contested guardianships. More of the guardianships that I have are consensual guardianships to begin with. And then after the consensual guardianship has occurred and gone on for a while, then the parent or parents will come back and say, okay, I want my child back. But so I understand, and I will now come and try to answer your question the best I can. I actually believe that the standard on the guardianship is not necessarily the best interest at all. I have to make the decision at that point in time, and so frankly, it's very nice. This sounds probably pretty rough, but it's very nice to me when I have a guardianship where it's a contested guardianship and I actually have the evidence that's of a level that I can say you're an unfit parent, the guardianship's in place. Does that answer your question, Senator?
Please.
Mr. Chairman, thank you. I think what we're hearing from the committee is, what are those factors that you're currently considering, that evidence that's brought before you that establishes unfitness at the time a guardianship is brought upon a petition, in those rare circumstances when that occurs?
Okay. Judge Blumel.
Mr. Chair, I'm probably going to miss something, and I'll defer to the attorneys on the committee and my other colleagues that they probably will have some more insight on this. But my initial thoughts to that are they almost literally go to the standard of termination of parental rights. And so is it a situation where this parent is able to provide a safe, secure home, a nurturing environment, and I believe that it may not be exactly the same statutory checklist of a termination of parental rights, but that's where my mind initially goes, Mr. Chair.
Thank you. Further questions of our judges? Yes,
Mr.
Senator
Chairman.
Nethercott.
If I may, in looking at this in this proposed bill draft, which only deals with the termination of a guardianship and what a court should look at on those circumstances, and if you have a copy of the bill in front of you, that might be helpful.
I do.
On page 2, lines 1 through 5.
Just a moment. Let me get it open. Page 2, lines 1 through 5.
Yes. Specifically on line 2, after the comma, it says the court shall consider the best interests of the child. But it doesn't say that the court shall not consider fitness.
Exactly.
The fitness of the parent is still to be analyzed upon the termination of a guardianship, correct?
It would be my position that I must make that finding, yes.
So upon the termination of a guardianship, it's your opinion, based on reading this bill draft, that you would have to make a finding of fitness of a parent, correct?
Yes, ma'am.
And you would also have to consider the best interest of a child, correct?
Yes, ma'am.
Thank you.
Okay. Committee, anything else from the judiciary at this? Oh, Senator Hicks.
Mr. Chairman, a follow-up. So I think my colleague has hit the crux of the issue for me, but under that scenario, we've gone through a fitness determination. And we bring in this concept of maybe marginally fit, but still meets the legal definition. Under that scenario, and you're sitting there and you've gone through the fitness test and there's a determination made, but you also have to look at the best interest in the child, and they're mutually exclusive. And you guys deal with this situation where you may have a parent that meets the definition of fitness, but certainly may not be in the best interest in the child. So under that scenario, how do you make a determination of which one of those factors is most important in weighing the decision? Then do you go through the rest of the bill draft and those things that are laid out? Because that's the real world and the dilemma. The needle that we're trying to thread is that very issue. Is that scenario where we have a case where there may be a determination of fitness that may not be in the best interest in the child. And that's the testimony that we've taken for the last 2 years. And that's what this committee is fundamentally trying to grapple with, is how do we thread that needle? And so do these other circumstances or scenarios that we lay out in the bill then help you make that decision, bar the constitutionality issue? We'll cross that bridge when we get to it. But with the other factors that we bring in now, does that now allow you to make a determination that if we get into these scenarios where we have a marginally fit parent but meets the legal definition, but it may not obviously be in the best interest in the child, that you can rule in the best interest of the child? Because if this doesn't get us there, and we've been spending a lot of time on a bill that is not what the intent of this committee is trying to grapple with. So I'd be interested under that scenario that my colleague laid out, how that plays out in your mind.
Mr. Chairman.
Senator Nethercott.
Thank you. Just to follow up on Senator Hicks. On his concerns, when you find a marginally fit parent, what tools are in the court's toolbox to handle that situation where you're not interfering with that parent, the marginally fit parent's constitutional rights, and how you're interweaving the balancing test of the best interest standard? And it's my belief, and I'm curious to hear your thoughts on this, that the tools provided in this bill that allows a transition plan back to that marginally fit parent allows the court some resources available to, upon a finding of a marginally fit parent, to transition that child back to the parent in a way that may address some of those concerns associated with the marginalness of the fitness, such as drug abuse, and maybe requiring drug testing associated with that transition plan to the fit parent. Is that a reasonable tool that this bill provides?
Judges.
That would be, my opinion would be that it would be very helpful for that. To Senator Hicks's question as to whether if you found a marginally fit parent, but that under the best interest, you found that it wasn't in the best interest of the child, whether that could somehow trump fitness analysis would be a question probably to be answered by the Supreme Court on the first appeal of that kind of case. But
If I may, Mr. Chairman.
Please, Judge Brunel.
I concur with Judge Day, and again, this is just my personal opinion, is that, and Representative Pownell actually asked a question, does this give additional tools to what I currently have? And I would respond with the answer, yes, it does. And I think that Judge Day summarizes it very well, where I look at this and I see the tool that I would use this for is a balancing test to say, okay, now what can I do and how's that going to work? And hopefully I would be able to have a record that would have adequate findings or adequate evidence, and then I could bolster that with my findings so that it would actually balance that and not unnecessarily invade the constitutional rights of a parent. I think that all of you, and I apologize, you probably have had this discussion and I've not participated in it. And so if I'm bringing up something, Senator, that I shouldn't, probably the termination, the petitions to terminate guardianship that I see more than others are exactly what I think Senator Nethercott refers to, and that's somebody who's become involved in drugs. They say, okay, they've cleaned up. I'm now sober. I don't have those problems. I've got a home. I've got a job. And then you have some tools with this that I think may be valuable. So if I've gone too far, Mr. Chair, please accept my apologies.
Representative Winters.
Thank you, Mr. Chairman. And Judge, I sure appreciate your being here. Some of the questions we've had over the last year regarding this bill, because, and to give a little background for myself, having adopted 3 children and being through the process that this is involved with multiple times, my heart was knit to the bill initially, but I do have a number of questions regarding it. And I would love to get your take on, so on page number 2, lines 7 and 8, the relative competency and fitness of the parent. When you talk about that relevancy, we actually are creating something that is subjective. And that's kind of the question that we've heard several times on page number 3, the quality of the relationship on lines 4 and 5. Again, a question of subjectivity. And then then on page number 4, lines 7 and 8, any other factor the court deems necessary and relevant. So what we come away with feeling in this bill is that it's expanded quite a lot to where the bill opens it up too far. And that in considering the factors that I've just brought out about the bill, do you feel like it opens it up too much, the current statute too much? It makes it a lot more subjective? Or how would you interpret the statute if this were involved in your ongoing decisions or your future decisions?
Judge Blumel?
Mr. Chair, in some respects, it's nice to be able to sit back as a district judge and say, well, that's a wonderful argument, counsel, but the law doesn't allow me to consider that, and just be able to address it very simply and succinctly. But I think when you deal with particularly the best interests of children, and you deal with this moving target that I think we have with children, and the broad range of factors that we can have in families, I personally don't find that this would be unreasonable and that it's too far or gives too many opportunities or options. But that's not really for my input. That really is yours as the legislature. If you choose to give those tools to the judiciary, then it's something that is discretionary, where we can say, yes, I find that to be worthwhile, or no, I don't. And when I make those decisions, I have to be mindful that I better have a reason for doing it so that it's supported from there. Mr. Chair, thank you.
Mr. Chairman.
I don't know if that responds adequately to your question, sir.
Senator Anselmi?
So Judge, what I'm hearing you say is there's no pH or litmus test that we can just dip this child in and come out with the absolute answer?
Yes, ma'am. If I may, Mr. Chair, yes.
Other questions for our judges? Thank you very much. Appreciate you
Thank you.
being here. And when we get back into committee discussion, there may be some additional questions or clarifications sought. Thank you. All right. State agencies, county agencies. Anyone would like to weigh in on this? Prosecutors, AG, Department of Health, EFS. Trying to remember all these names. No. All right. With that, folks, we're going to go to public comment. And if you could keep your comments short and to the point so that we have time for everyone to speak to it and address the bill. Let's talk about the bill in front of us. So with that public comment, please come up and announce yourself. If you're affiliated with an organization, let us know who that is. Thank you. Hold on for a second, Donna.
Mr. Chairman, members of the committee, I'm Donna Sheen, and I am the director of the Wyoming Children's Law Center. And I come and want to speak in favor of the bill. I guess generally what I would say is that our guardianship laws do need a lot of work. And this is a particularly important part of our guardianship laws that has been left undefined for far too long. And I would support everything that the judges testified to. One of the things, though, that I would say is I believe we need to stop using best interest of the child so much as to talk about balancing children's rights, because there are certainly situations where a fit parent, putting a child back with that fit parent is absolutely definitively going to cause harm to the child. children have rights too, and we have to recognize that. And currently, our guardianship law doesn't address that. So this is an important way that we can add back in the ability of courts to balance that and ensure that children are not placed back in a situation that could be emotionally harmful, that would end an important relationship, that would put them back in fear when they've just recovered from perhaps some devastating, post-traumatic stress, or they're still struggling with that. And so we really need to put this protection into the law, and I would urge your support, and I would stand for any questions.
Questions for Ms. Sheen? Thank you.
Thank you.
Ma'am?
Mr. Chairman, thank you. My name is Lindsay Sears, and I am the president of Homeschoolers of Wyoming. And I would like to stress the importance of not passing a bill which allows the court to determine the best interest of a child without first finding the parent unfit. A case just decided in the Georgia Appeals Court illustrates my argument. The Georgia Court of Appeals issued the decision last month reversing the trial court's decision in Borgers versus Borgers. The trial court stated the following about homeschooling. The court finds it to be a shame that the defendant mother has not taught her children to be independent. The court finds the child's enrollment and attendance at the Montessori school should be convenient. The appeals court reversed, and Chief Judge Dillard wrote a special concurrence which states in part, the liberty interest of parents to direct the upbringing, education, and care of their children is the most ancient of the fundamental rights we hold as a people and is deeply embedded in our law. This cherished right derives from the natural order, pre-exists government, and may not be interfered with by the state except in the most compelling of circumstances. I write separately to express my serious concerns with the court's decision to summarily substitute its judgment regarding the child's education for the mother's without identifying evidence of the compelling circumstances necessary to interfere with her constitutional parental rights. While the trial court may be right that it would be more convenient for the child to attend the Montessori school, a parent's constitutional right to make educational choices for his or her child is not limited to those a judge or any other state actor deems to be convenient or wise. And when the state actors engage in this sort of Orwellian policymaking disguised as judging, it is any wonder that so many citizens may feel as if the government does not speak for them or respect the private realm of family life. In sum, I take this opportunity yet again to remind our trial courts that in making any decision or taking any action that interferes with a parent-child relationship, our state statutes are subordinate to and must be construed in light of the fundamental rights recognized by the federal and Georgia constitutions. So this guardianship bill would wrongly allow for a court to decide it thinks a guardian is a better choice based on the educational needs. If you see in the bill, page 3, line 9, the bill says the ability of the parent and the guardian to meet the child's physical, emotional, developmental, educational, and special needs. Thank you.
Thank you. Any questions for Ms. Sears?
Mr. Chairman.
Yes, Senator Nethercutt.
Thank you, Mr. Chairman. Ms. Sears, is that correct? Do you disagree that some parents' rights should be terminated?
In specific cases,
They should be terminated?
I agree.
And do you believe in some cases that involuntary guardianships are appropriate when a parent is on drugs or harming their child through child abuse?
I agree.
And what do you think those standards should be?
Ms. Sears?
The standards for
a court to consider when deciding to take away a child from an abusive situation?
Well, there are many standards that need to be considered. Obviously, if they're breaking the law, I believe that is a factor to consider.
And do you believe that this bill says otherwise?
I just believe that this bill does not put first the parents' rights.
If I told you that the bill required a fitness determination of the parents, would you feel better about the bill?
Yes.
So if it was true and you heard from the testimony from the judges that that requirement is still within this bill, do you feel better about it?
I'm not sure.
If I told you that was the intent of this bill, do you feel better about it?
Let's direct the comments back and forth through the chair in both ways, please.
I would have to make a further reading.
And just one more comment, Mr.
Yes.
Chairman.
Follow up.
The statement that you read was the writings of a judge, correct?
Yes.
From the judiciary.
Yes. It was also reversed from another trial court.
Yes, Representative Winters.
Thank you, Mr. Chairman. And to keep from turning this into some sort of legal battle, as though it's a courtroom, I do want to just ask a question, though, of you. Is it just your concerns with the bill would be that you're afraid of what this may potentially do in the future, unintended consequences, regardless of intention? The intentions of the bill are to address a certain issue, but are your concerns that they may be misused, say, a couple decades from now, to where it may infringe upon the rights of a parent in a different circumstance? Is that your fear?
Mr. Chairman, yes, that is my fear. Exactly.
Right. So, Mr. Chairman, so thank you. So your questions are not necessarily regarding the intention of the bill. It's on its potential misuse at some future date.
Yes.
Thank you.
All right. Any other questions of this witness? Yes, Representative Jennings.
Mr. Chairman, Ms. Sears, thanks for being here this morning. I just want to play a little bit on Representative Winters there. If you have the bill in front of you?
I do not.
Oh, I'm sorry. So throughout the bill, I think, if I'm understanding you correctly, your concern is things like the vagueness of close and, on page 2, close and substantial relationship, who gets to determine that. Page 3, a parent-child type of relationship, who gets to determine that. The quality of the relationship, who gets to determine that. You're seeing a shift to the government or to the state to making a determination on these vague factors, or even to the court, based upon the state's assessment of those. And that seems to be adequate care on line 12, or how the child interacts or communicates. So if a child didn't speak for a while, then the expert could come in and say the parent is not being very fit here, or there's an issue, or it's not being adequate. Am I understanding you correctly that you see the vagueness and who determines those things as being very serious for parental rights? Thank you, Mr. Chair.
Yes, Mr. I would agree. I do not think that there is enough language in the bill to determine the unfitness of a parent.
All right. Any other questions? Thank you, Ms. Sears. Other input, public comment? Sir.
Chairman, my name is Douglas Petersma. I'm a father and an education specialist.
Sorry, your last name?
Petersma.
Okay.
I'm a father and an education specialist. I direct a homeschool auxiliary here in Cheyenne, Wyoming. And I would like to speak to the importance of protecting a child's liberty right to be raised by a parent unless the parent is determined unfit. The bond between parents and children is one of the most powerful of human relationships. Policies affecting these relationships have profound ramifications for our society. The role of a parent in a child's life is an irreplaceable one. Dr. Jack Shankoff, board-certified pediatrician of the Harvard Graduate School of Education, says, even when young children spend most of their waking hours in childcare, the parents remain the most influential adults in their lives. Dr. Shankoff also said the hallmark of the parental relationship is the readily observable fact that this special adult is not interchangeable with other adults. In a 2004 Nebraska Supreme Court case regarding guardianship, the court said a biological or adoptive parent's superior right to custody of the parent's child is an acknowledgement that the parents and their children have a recognized unique and legal interest in and constitutionally protected right to companionship and care as a consequence of the parent-child relationship, a relationship that, in the absence of parental unfitness or compelling state interest, is entitled to protection from intrusion into that relationship. Hence, the parental superior right to child custody protects not only the parent's right to the companionship, care, custody, and management of his or her child, but also protects the child's reciprocal right to be raised and nurtured by a biological or adoptive parent. Establishment and continuance of the parent-child relationship is the most fundamental right a child possesses, to be equated in importance with the personal liberty and the most basic constitutional rights. The bill draft as it is being considered in section 1, subsection B, page 4, lines 10 through 13, states that the court may consider the factors in subsection A of this section without first making a finding of parental fitness or a finding that the guardianship is no longer necessary. Mr. Chairman, I ask you not to move this bill forward unless and until a change is made to include that the court must find the parent unfit before determining the best interest in guardianship change when the parent objects. Thank you, Mr. Chairman.
Thank you. Any questions for Mr. Petersma? Thank you, sir. Public comment. Ma'am?
Chairman, I'm Jan Loftus. I'm a volunteer coordinator for parentalrights.org in Wyoming. And I provided you with a yellow folder with a couple handouts today. I want to mention the bill passed last year and the historic tradition of parental rights, that they are one of our fundamental rights. And last year it was put into statute that the state cannot interfere without a compelling interest. This is the highest level of protection if we think about our other fundamental rights, that the state needs a compelling interest to interfere with this familial relationship. The U.S. Supreme Court calls them liberty interests and family privacy interests. In the one handout I provided, it's a parental rights tradition in U.S. Supreme Court excerpts. I highlighted two. Quillian case where it says unfitness must be decided before best interests. The Santosky case, fundamental rights do not evaporate because the parents have lost temporary custody or have not been model parents. I would like to suggest that if the bill was to move forward, that the idea of fitness not be implied, but be stated, as it's currently been said on the committee today that it's implied, but it should be actually put into the statute. The burden of proof, if the parent wants to stop the guardianship, if the parent was adjudicated unfit in the past, the burden of proof should be on the state, not the parent to prove fitness, but the state to prove unfitness. Why do I say that? Well, how would we prove ourselves fit as parents? If you think about your own situation, how are you going to prove it? And now imagine that you're young and you're poor. How are you going to prove that you're fit? Does it set up an impossible situation so that this bill would turn out to be a termination bill instead of what it's intended for? I also want to speak to the relative competency, and that doesn't consider the special, unique relationship that parents and their children have, that is a different relationship than children have with other people. On the case, the Wyoming Supreme Court case SRB 2009 that I also provided for you, I highlighted a few things, but the orange highlight: in guardianship termination proceedings, as in appointments, the biological parent is entitled to custody of his or her child, absent of finding she is unfit. One last thing, there's good policy rationale for encouraging parents to agree to temporary emergency appointment of a guardian. Parents will be reluctant to do so if they learn that later they're going to have to demonstrate fitness in order to terminate the guardianship. On that same SRB case that I provided in pink highlight, the court said that it would unnecessarily place children in jeopardy if the parents are reluctant to put their kids in guardianship when they ought to. Representative Stith asked me about lengthy guardianships, and that's also discussed in the same case, highlighted in yellow. And I would propose that the committee consider some date or maybe individually a brief bill that addresses just this point. And it's, I think, a very good write-up the court made in this case about the concerns over very lengthy guardianships. Thank you.
Thank you, Ms. Lofty. Questions? Witness? Thank you. Is there any other public comment?
Chairman, members of the committee, my name is Cassie Craven, and I am with the Wyoming Liberty Group.
With which group?
The Wyoming Liberty Group.
Okay.
Mr. Chairman, members of the committee, this guardianship bill and its intentions are very admirable. I commend these fine people who have been raising these children when the parents are nowhere to be found. However, I believe that the bill in its current and existing form will only increase litigation. It will put people at an economic disadvantage at significant risk of losing a fundamental right. And I don't believe that it would be in the best interest of the children to have a long drawn-out guardianship and uncertainty. Moreover, disparate results will result from this bill. Different judges in different jurisdictions will interpret these factors differently. There will not be consistent precedent to rely on, and each and every case may end differently depending upon the judge that you have to see. This bill will ensure work for private practice attorneys, no doubt. There will be litigation and there will be appeals to the Supreme Court. This bill will also put undue burden and additional cost on the state. When you're talking about taking a fundamental right, I believe that court-appointed counsel is necessary, court-appointed guardian ad litems are necessary, and I don't know if that's a consideration that's been fully thought through. Parental rights are fundamental and protected, but I believe that I have a better alternative for this committee to at least consider and perhaps begin researching. 14-2-310 allows for persons authorized to bring termination petitions and qualify standing. Why should a child be hung out in limbo for possibly years? Does a parent get to decide when it's appropriate to parent their child and when it's not? And do they get to come back years later? The solution to this problem is to create standing in a different way, not to slowly chip away at fundamental parental rights and try to shoehorn it in where it doesn't belong. I don't know what the ideal solution would be, what the appropriate time limit is for a termination petition to be brought. But I think that somebody who's raising a child when a parent has abandoned them or abused them ought to be able to have their parental rights at risk. But those rights should be terminated, not slowly chipped away at. To do so would only derogate what is established clearly by the Constitution. And we need to pick a side here.
Okay.
I have a few issues that I'd like to address. The guardians as protectors propose that the burden of proof in these guardianship proceedings should be on the parent. And I believe that's not in accord with the Constitution. There is no guardianship right. There is a parental right. And so that's the sticking point. Additionally, in their memo, they cite the statutory authority that allows for the state to intervene, but unfortunately in these circumstances, guardians don't have rights and they're not wearing the white hat of the state. And I would ask this committee to consider why, if the abuse and abandonment was so severe, why DFS hadn't already intervened. I think that the appropriate response would be to consider that standing in a termination proceeding. Up the ante and let the judges decide, is there enough evidence here that this person's parental rights should be taken away? Because if these cases are so severe and if the facts dictate that, then I believe that there might be a way to craft that solution. In the Truth About Troxel memo proffered by the Guardians as protectors, the group states in part, the Troxel case lacks applicability for the Wyoming children, currently in involuntary guardianship proceedings. They pick apart at the facts and how it's different. But I pose to this committee for serious consideration, does the Troxel case lack applicability for the Wyoming biological parents who have a fundamental and constitutional right? And in closing, I would like to address a few of the comments that I've heard already. Senator Kinski, I believe, yes, addressed the presumption concerns, and I share those deep concerns. And the balancing of the factors that makes this a horse race. Again, the results will be different in every single jurisdiction with every judge that you see. And maybe they're not the best parent, but they are still the parent. And I agree with that. And I'd like to reiterate that because until that fundamental principle changes, we're chipping away at a right. Even LSO conceded this morning that the disparate impact of Troxel across the states has been noted. And it is of note that 28 states have adopted a bill similar to this, but not to the extent to the bill that you see today. And some have been litigated and some have been overturned, or some have been recrafted to come into accord with the Constitution. Even Judge Day couldn't answer what constitutional implications that this bill might have, and it's been alluded to that it will end up at the Supreme Court. So to covet Senator Hicks's concerns, how do we thread this needle? And I think that we can come up with a cleaner remedy that would be better for the children, better for the parents. Because again, parents shouldn't get to decide the time schedule by which they parent their children. And there should be a time and there should be a place where they can lose those fundamental rights. But chipping away slowly in an uneasy way that's very unpredictable and tenuous in the court system is not the way to do that, in my opinion. And I'd stand for any questions.
Thank you, Ms. Craven. Questions, this witness? Yes, Representative Winters.
Thank you, Mr. Chairman. So based on the things you just said, I guess the question that comes to us, and then the question regarding the bill is this. Should a parent have to fight for termination of guardianship to the same extent that someone would have to fight for termination of parental rights? We heard from one of our judges that currently it's almost at the same level now. And so with that in mind, does this bill actually make it less or more difficult to terminate guardianship? And does it place more burden on the parent or does it lessen that burden?
Craven.
Mr. Chairman, Representative Winters, I believe that the bill in its existing form closely parallels a termination proceeding, but the way that it's being done, we don't know how it's going to end up, how long it's going to take, and it puts an undue financial burden, I think, on the parent. I think based on the testimony we've heard at length regarding some of these fine people, we're going to be looking at parents of the children who can't afford attorneys and can't afford a lengthy battle. And I just wonder what would happen in those circumstances. Whereas a termination proceeding on the proper timeline, and I'm not sure what that would be, I'd be happy to work with the committee toward that, would allow for fundamental due process protections. Whereas I don't believe that this does that. And moreover, I'm very concerned that it attempts to shoehorn in the modification of custody standard, which is you can bring it every 6 months on a change of circumstance. And I would just encourage the members of the committee to remember this is not a custody battle. This is a parent and a guardian. The rights are different.
Okay. Any other questions? Yes, Representative Jennings.
Mr. Chairman,
Cravens.
So do you feel like that this could be perhaps approached easier through amending current statute, or something that would be a little less vague and a little more? And then secondly, I noticed that there's not in the memo a fiscal, that there will be court appointed lawyers brought into this. Is that something that that you or maybe some other lawyer can address a little bit of that? What are we looking at?
So do you have a question for Ms. Craven, or should we go? Are you talking to LSO?
I'm sorry, Mr. Chairman. The question was did she feel like that there was a way to address this in current statute, to perhaps amend current statute that would be easier and more concise?
Okay. Ms. Craven.
Mr. Chairman, Representative Jennings, I propose 2 changes. First, I propose amending 14-2-310 to consider standing for these people. on a timeline that would be in accord with the Constitution, and that might require some research. Secondly, based on the testimony we heard from Judge Day this morning, I now think it would not be a bad idea to consider in the current bill something that allows for a graduated schedule and return in guardianships. I don't see how that would be an implication on constitutional rights so long as it's done under an appropriate timeline.
Okay.
And to answer the final question, I apologize, Mr. Chairman. On the fiscal note, I do think that that is a concern that has been not discussed, at least in the meetings that I've attended. How are all these court-appointed attorneys going to be paid, and what kind of influx are we going to see in those numbers?
Okay, Senator Nethercott.
Mr. Chairman, thank you. I want to remind the committee what we're dealing with here are private actions with family members, typically for private guardianships. I think it's easy to confuse some of these concepts and scenarios that take place when the state comes in and takes a child, as Ms. Craven has referred to, in a termination proceeding because of abuse. And in those circumstances, when a parent's rights are being terminated, there are due process rights that attach because of those constitutionally protected interests. And in those circumstances, the court does appoint attorneys for those parents to represent them in those actions. In this particular case, in this particular bill, we're dealing with private party actions. And again, I want to remind the committee that the timing of the action that we're talking about in this bill is at the end of a guardianship, when a parent on their own initiative moves the court to terminate a guardianship. And the court is still required to determine whether or not the parent is fit under this bill. But what this bill does differently, and we've heard provides an additional tool to the judges and to the families, is requires the court to actually look at who this bill is putting first, and that's children. And says, you know what, this parent may be fit. We're going to also look at what the best interest of this child is in light of the fact that the parent has been absent for a period of years. And so we're going to walk this through very carefully and understand what works best for this child and what works best for this family in light of the unique circumstances that each family faces and that each challenge faces. I suggest to you that I'm very concerned about the particular testimony we've heard that truly is speaking out of both sides of the mouth here of this preservation of parental rights and yes, this push to terminate. And so it seems to me that the body is being asked to ignore the value of this bill for guardianship and instead focus on a faster, more quicker approach to actually terminate rights. Ms. Craven referred to Title 14, and the timeline for terminating rights by the state for a parent is 15 months. 15 months and you can terminate somebody's rights. My understanding of what the committee's wishes is that would not be appropriate, particularly in light of the legislature's previous activity of passing the parental rights bill. And instead, this guardianship bill acknowledges that families are complicated, as well as drug addiction and abuse and mental health issues, and that those are not finite circumstances and that those are fluid, as is the human condition. And this guardianship provides additional tools to courts in this very rare circumstances where this is happening to ensure that both parents' rights are met, as well as the interests of children. That's what this is about.
Is there a question in there for Ms. Craven, or is more a response to her comments?
Mr. Chairman, I was responding to the question of Representative Jennings, who was asking about court-appointed counsel,
All right.
understanding the distinction between state action and this private litigation.
Thank you. Representative Winters.
Thank you, Mr. Chairman. And so I suppose this could be for either Ms. Craven or Senator Nethercott, but so I know that right now,
if we're going to get, is it going to be more of committee discussion? Because
No.
we may be able to clarify some of this with some LSO.
But I'm actually, Mr. Chairman, I'll explain what I'm doing. I just need some clarification regarding how this would actually work in current legislation. So I know that right now, if 15 out of the previous 22 months, the child has not resided with their parent, then you can potentially call for that child to be placed in a different circumstance, a more permanent circumstance. So would this bill then be contemplated sometime before that 15 of 22 months or after? When does this bill actually take place in relationship to when the parent would petition to have the guardianship terminated so that they can actually take custody of their child again. Where on the timeline would this bill most likely fall into place? I'm not sure who to address the question to. I'm just trying to see the sequence of events in a court proceeding.
Perhaps we could come back to LSO and if you'd like to weigh in on that particular question as the crafters.
And Mr. Chairman, it may actually be best directed toward our judicial branch as well. But I guess I'm trying to see that particular picture there. There is value in the bill. I understand in certain circumstances. I'm just questioning how broad we are and what we're doing on the timeline.
Tell you what, we're kind of getting into a lot of discussion back and forth that maybe we can work on. And is there any other particular questions to be directed to Ms. Craven? Yes, Senator Kinski.
I just want to make sure that I'm understanding clearly what I think you said. So let me repeat back in my own words. In the typical situation that we heard the judiciary describe so far at every meeting that we've considered this, there's not a nice, neat little timeline. It's usually mom is gone, dad's unknown, grandma and grandpa have had the kid for 2 years. Mom finally shows up and thinks she's cured. So there may have been a determination of unfitness at the outset, or it may be that they're just now getting to court because they're afraid of giving the kid back to mom. So maybe we've got essentially sort of a retroactive finding of unfitness, and the judge is left with this sloppy situation. I heard you say in a situation where there's some question about the parent's fitness, you think constitutionally it's permissible to explicitly give the judge some tools to assess whether, not to just say on a binary determination, okay, you're fit, here's your kid, to say, we're going to put some parameters here. We're going to kind of ease the child back into the situation. We're going to see if mom really is fit and see if she really is stable. And we're going to try and protect the kid from an abrupt ripping away from these grandparents. You feel like that would pass constitutional muster, whether initially there was some question about the fitness of the parent?
Ms. Craven.
Mr. Chairman, Senator Kinski, I'm in support of a tiered return schedule upon a finding that a parent is fit, so long as the time is reasonable and due process is afforded. I think that would be perfectly appropriate. And from the testimony I heard from the judges this morning, something that is needed. But as far as these presumptions and the burden of proof, it goes too far.
Thank you, Mr. Chairman.
Representative Winters.
So thank you, Mr. Chairman. This would be a follow-up to that question for you. So based on your testimony before, you mentioned 14-2-310, which is the termination of the parent-child relationship. So then based on this exchange that we just had, do you think that a graduated schedule would be best placed under 3-3-1107, which would be created actually at this point? Or do you think it belongs under 14-2-310? I don't see it belonging there. So would there potentially need to be something enacted similar to this that would create a graduated schedule, in your opinion?
Ms. Craven.
Mr. Chairman, Representative Winters, yes, it would not belong in 14-2-310. 14-2-310 would only dictate when a parent could be terminated. The appropriate place for a graduated schedule would be in the guardianship section of the statutes. And I also wanted to address, if I could, that while these might be private party actions, the Troxel case and its progeny very clearly state that when a third party, that's the phrase, third party, is attempting to intervene in a parental right, that triggers due process. So it doesn't matter that it's a private party. And I believe that it's talking out both sides of the mouth to encourage the primary concern of best interests of the child and the child's rights. Show me in the Constitution where the child's rights are. There's a reason they have guardian ad litem. They're minor children. And while their best interests must be noted and considered, there's a constitutional right to being a parent, and I can show you where that exists.
Okay. All right. Yes, Representative Olson.
Thank you, Mr. Chairman. Ms. Craven, you're a lawyer for Liberty Group, is that correct?
I'm an attorney in private practice, but I do hold a contract with the Wyoming Liberty Group, yes.
I may be too simple-minded of a lawyer. When I read this bill, and I have heard testimony today from you and others. The testimony from you is that the legislation as crafted doesn't require a finding of parental unfitness, though I heard the reverse testimony today as well. As I read page 4, lines 10 through 13 of this bill, what I read is that the bill allows for judicial discretion to bypass parental fitness and simply rest on a best interest of the child analysis when determining whether the guardianship should continue or not. Is that your reading of the bill when you speak about the lack of parental rights inside of this bill?
You have a copy of the bill.
I do. Mr. Chairman,
Thank you.
Representative Olson, it's my position, not on what the bill says, but it is my position that there must be a required finding of fitness of the parent, or this will not pass constitutional muster. It's been stated that it's implied in the bill, but I agree with Ms. Loftus. It must be stated explicitly, or you face, I think, pretty severe consequences that it will be overturned by the Supreme Court. We can't infer a constitutional right. It needs to be stated explicitly and be clear. I don't believe that it would be constitutional for a judge to bypass that and only consider best interests of the child. I would, I guess, argue that a balancing test might be put into place in terms of, how much we weigh the best interests of the child. But I don't believe there's any question in any case law that the Supreme Court has found that the fundamental parental right has to reign supreme.
Follow up, Mr. Chairman.
Yes,
So, Ms. Craven, let's just look at the language of the bill. On page 4, line 10, it begins, the court may consider the factors in subsection A of this section without first making a finding of parental fitness or a finding that the guardianship is no longer necessary. What does that mean?
Mr. Chairman, Representative Olson, you'll see I have that exact provision highlighted on the copy I'm looking in front of me because I don't know what that means. I think what it means is that the bill as it exists today is unconstitutional.
Any other questions? Ms. Craven. Thank you very much.
Thank you, Mr. Chairman. Thank you, committee.
Okay. All right. Is there any last public comment? Ma'am? Come on up and speak in the microphone. Since this is being broadcasted, please, even though you've introduced yourself before.
Oh, sure. Okay. I'm Annie McLaughlin, associated with Wyoming Guardians as Protectors, grandmother. And so I've heard a lot of, I won't take too long. I do agree with, obviously I'm favoring the bill. We passed out just as humbly submitted amendment suggestions that might strengthen the bill. Because I know that, the homeschoolers, and of course, my daughter is evangelical. She homeschooled her kids for 3 years. I get it. She's a great parent. We're not talking about homeschooling. And we don't want to have a bill that the people have to testify against because they're afraid that there's unintended consequences, obviously. So I remember one time, Chairman, where I believe it was Senator Kinski says that maybe we need to tailorize this bill very narrowly to make sure that it doesn't exclude or that it doesn't, bring on those unintended consequences. Obviously this bill to me is not about homeschooling. And if you would, let me get my phone. Do I have permit? Can I get my phone? I wrote something on it that I wanted to say to you.
Certainly.
But I think it's a great bill. I do think that, obviously none of us, I believe in the Constitution and the parents have a presumptive right to control the care, custody. Of course, no one in this room doesn't believe that. But we also know that, and I'm not going to argue case law, I'm not a lawyer, but I read, and of course there's just as many cases, if not more, that say very differently that if the presumptive right prevails unless there's a compelling state interest to show that there's harm or detriment to the child. This is certainly a case where we've got harm and detriment to these children. And I like the law because it doesn't terminate rights. Now, you all know that my grandson's father was just sentenced again, who was actually going to go back by the judge to him. And then he got caught with meth and a gun and counterfeiting, and now he's sentenced to 10 years in prison. It's a sad thing for my grandson. I have a daughter who I love. I've tried to help. And my story is, I'm saying the story not because to focus on me, but my story is common. I was in health, Chairman, I was in health reach yesterday because my grandson had an ear infection. He had a fever. So I went over there on Del Range. I was there for a long time, and I struck up a conversation with a woman. She goes, "Oh, how long have you been waiting?" "Oh, my grandson's sick." "Well, my grandson's in there." And I relayed this to Chairman Kirkbride last night, and she said, for a physical, "I'm raising mine," she said. "Oh, really?" I said, "Well, I'm raising mine." "How many?" "3. "How many for you?" "3. I said, "Can I ask you, under what circumstances are you raising your grandchildren?" And she said, "My daughter's on meth, and there's different fathers for different children." And I said, "Well, then you have guardianship. Did you know about our organization?" I handed her a card. She actually teared up. She says, "I thought I was the only one." This is everywhere. I just got a call a couple months ago from a family in Star Valley with 3 kids. The grandpa just died of cancer. The mom's on meth. And I met this woman because my daughter practices medicine at Mayo, and her colleague's sister is the woman on meth. So she asked, "Can I have her call you?" And she doesn't have any money to raise the children. She wants to get power, but mom says that kicks in child support payments, so she can't. So this bill really, I like the bill too because I don't want to have to terminate my daughter's rights. DFS did that in 05, and it damaged her. And I've had her in my house when she shows up homeless. I like this bill because it takes away the threat of a parent can just waltz into court and say, "I'm fit because I'm going to use that power money and that housing to get the drugs." And that's what they do. I don't know if any of you are familiar with really the drug culture, but I am. I volunteered at Comey. I see the people. And this bill, let's fix it. Let's fix that narrow language in to exclude homeschooling or the parents who give Cheetos over apples. That's not what this is about. And to respond to some of the other comments, when we go to court, the parents show up pro se. I mean, was that the right word? They come in, they don't have an attorney. They get what they just come in, "I'm fit." We pay $300 an hour attorneys, and they tell us they're going back because we don't have standards in place that fine-tune what constitutes unfitness. And why in the world shouldn't the parent, if we look at those amendments, it talks about the compelling state interest to secure a child's right to a stable home environment and to preserve the existing loving child-parent relationships. I would love it if I had a daughter who could say, "Mom, I'm gonna clean up," but she's been on drugs for 28 years. And I don't want to terminate her rights because I don't want to hurt her. This allows me to protect the child and know that she can't just waltz in without saying, "Okay, Judge, I know I've been on drugs because you found me unfit in 2013, but this is where I went to treatment. And this is where I did this." And I would open arms to her. I would buy her a house. I would put her on my rent. We don't want to terminate our own child's rights. This is a beautiful law because it needs to be fine-tuned because we don't need people to come up from the homeschooling thinking that a judge is going to find them unfit because they're homeschooling. So let's look at those issues. And in terms of altering the standard of fitness, if I could just say, they should have to prove that they are fit. If they're found unfit for abandonment and neglect and ongoing drug use and perpetration of domestic violence, whatever this is, and combination thereof, in my situation, my grandson turned 6. They've been gone 4.5 years. That's a long time in a child's life. So, and I'm just one of many stories. So this is about if there's a problem with the fitness thing, there is, I took it upon myself to read LSO's memo last October, which was great. And the Wyoming case law regarding unfitness factors of biological parent. This is by the 12 factors that the Wyoming Supreme Court found that will in sufficient combination support a conclusion that the child is unfit. 12 factors. So that would be great to incorporate that in the law. And one of the biggest ones is the child has a history of parents surrounding himself or herself with child with unsafe individuals. And then, of course, the big one is on criminal behavior as particularly as it relates to ongoing drug use and addiction. We live in a culture of drugs, and it's hit Utah, it's hit Maryland, it's hit Wyoming. And we know that there's 11,000 kids, and that's just the kids on the radar, not the ones we don't know about. I have a letter from Debbie Walter, who wanted to be here today. A lot of people wanted to be here today, but grandparents have to work to support their kids. So, but Debbie Walter she takes in all the guardianship cases, around here. And
Do you have copies of the letter we could circulate rather than read?
Oh, I won't read,
Series
but I'll
of
give you a
letters.
copy. I'm sorry. Basically, she just says that over 90% of the kids that are the guardianships that come in are because of debilitating drugs and abandonment and abuse and traumatic. Kids are exposed to traumatic episodes far before they ever get guardianship. And so we're not talking about homeschooling. Let's get this narrowed to where people say, okay, because a presumptive right only applies when a child is not in danger. And that protection of harm and danger, and like Donna Sheen said, they have rights. And it has, and I'm not going to go and quote laws because we have it all over our website. We're smart people. We contact law professors, we contact attorneys at UW, and we say, show me laws that we can put on our website. So this is in a matter of who says who or what laws. We all love parent rights. I'd be really upset if somebody said I wasn't a fit parent because I don't feed them right or because I decide to homeschool. So please, let's get this bill right, and let's don't make it something that it's not. This is a serious problem, and it needs a serious fix. And I'm not making this up. It's statewide, and we have to get your vote to fix this. So task force, I don't know. That's all I have to say. I appreciate your time.
Do you have any questions of this witness? Questions? Thank you.
Thank you very much.
All right. Is there any other public comment? All right. We're going to close public comment and bring it back to the committee. Committee discussion, motions, whatever you'd like to go.
Mr. Chairman.
Yes, Senator Kinski.
Well, I'm going to go back to, it was either last summer or the summer before when we were in Sheridan, and what we heard from the judge at that time was similar to what we've heard today. The ask was fairly humble, which was in these cases where I know Judge Day used the word marginal, but I think other courts have struggled with that very concept. It's not a new concept. It's on page 8 of the Fuller memo, where parents can meet the minimal requirements of parenting. And that's where the real struggle is. And that's the cases they see most often. And the district court judge that we heard there said, is the law that they're either fit, not fit? And if they're fit, I got to give the kid back, and that's the end of the guardianship. Some of us read it that way. Or do I have the ability to kind of fashion a reintegration plan? It's not explicit in the law. Some of us as judges do that, depending on the circumstances, some of us not. So the ask was just for some language added on to, just very briefly, that just spelled out what kind of remedial measures a judge can undertake in this case where the parent may or may not be rehabilitated, may be struggling, so that they can protect the kid in case the parent relapses. But if the parent truly is rehabilitated and this reintegration plan works, that parent has a right to their child. That's the end of the discussion at that point. But they just wanted to have some clarity in the law that they've got the authority to kind of fashion some relief or reintegration And this bill goes way beyond that, I think. And I don't know how to fix it to get it to that. Probably we should have started with asking the judges to give us an outline of what they thought would really help. But I think this bill goes too far from the real issue that's being presented to us, as I understand it.
Okay. Yes, Representative Stitt.
Mr. Chairman, thank you. I have a proposed amendment. I won't spend too much time belaboring it.
We've got a motion to move the bill. Do we have a second? We finished public comment. Yes. So we've got a motion from Senator Nethercutt, second from Senator Anselmi. Representative Stitt.
Mr. Chairman, thank you. I have a proposed amendment. I won't spend too much time talking. It's similar to what I've mentioned in prior meetings on this topic. It relates to due process. I think we have to address due process because due process does provide heightened protection against government interference in certain fundamental rights and liberty interests, of which the right to be a parent is one. So the specific amendment, and I do have it in writing, but to start with the important part, we start at page 4, lines 10 through 13. And it proposes to delete lines 10 through 13 and to replace with the following: the court shall grant the petition unless the court finds that there is a compelling state interest in preserving the guardianship. The court shall deny the petition if there is a compelling state interest and it is in the best interest of the child to preserve the guardianship. It's the guts of it. That way the court has clear direction of what it's supposed to do, and we incorporate the notion of making it a specific finding of a compelling state interest, because I think if we don't do that, then we've got something that's unconstitutional, in my view. This amendment also includes some conforming amendments on page 2.
You want to put these together or do them one at a time?
I think that needs to be together because the conforming amendments just makes it consistent.
So this is all one amendment?
All one amendment, yes.
Where's your next?
Page 2, line 3. On line 3 of page 2, after the phrase interests of the child, delete the remainder of that line and replace with and determine whether there is a compelling state interest in preserving the guardianship, period. And then on line 4, just to preserve the grammar, you delete the phrase the child, and in front of, and also on line 4, in front of the words the court shall consider, have the phrase in making that determination. And the purpose of this page 2 amendments is just to make page 2 sort of consistent with the amendment on page 4.
Okay.
And that's the
Any questions on the amendment? Do we have a second on the amendment as proposed?
Second.
Got a second from Senator Hicks. Discussion on the amendment. Representative Winters.
Thank you, Mr. Chairman. I don't think it's discussion. I think it's just a question of would that then need to change some things in the enacting clause and different things. As far as making sure that compelling state interest is highlighted right up at the title. Maybe it's a question for LSO.
Senator Nethercutt, do you want to weigh in on that one at this point?
No, I'll let Alice
Okay.
answer the question.
Ryan.
Mr. Chairman, if I understand Representative Winter's question about the bill title on page 1, depending on what amendments are passed and what changes are made to the bill, we would change that bill title accordingly, unless the committee wants to specifically delineate what should go in that bill title.
Okay. All right.
Chairman.
Yes, Senator Kinski.
I'm against the amendment. I'm not sure that's really helping us much. Interjecting compelling state interest into the mixes, and in my mind causes more, not less, confusion. If the amendment we're talking about a threshold finding of fitness or unfitness, I think it would be more compelling. But as written, I have to oppose it. Thank you, Mr. Chairman.
Discussion on the amendment.
Mr.
Senator
Chairman.
Nethercutt.
Thank you. Just a question for Representative Stitt. And in response to Senator Kinski's comments and the concerns of of the public. Concerning this particular section, lines 10 through 13, just did you consider maybe instead of confusing the issue with compelling state interest, just to add it unequivocally to state that the court shall consider the fitness of a parent in making this determination? Just that statement, just unequivocally stated, so it was very clear for the court, very clear for the public what the standard is. You feel that's a different standard?
Representative?
I'm not opposed to including some finding that in order to grant the petition, the court would need to find that the parent's fit. I think that's kind of that's stating that would be clear. Doesn't bother me. I think that's sort of implied because the the whole premise of this is that you have a biological parent who at some time in the past was not fit because perhaps the parent was incarcerated. Now they're not incarcerated. They're not working. They're coming before the court asking to terminate the guardianship. So
Would you like to, are you open to amendments or would
Yes,
it be
certainly.
cleaner to restate the whole thing?
I'd call the question.
Question on this one. Take other.
and if I may, Mr. Chairman,
Your amendment.
we haven't talked a lot about, we've talked some about due process, but if we don't address due process at all, this bill is not going to survive judicial scrutiny someday. And so we have to have something in here. And the way to satisfy due process under Troxel v. Granville, I think, is to talk about a compelling state interest.
Question's been called. All in favor of the amendment as stated, two parts, two places in the bill language. All in favor, say aye.
Aye.
Opposed?
No.
Ayes, please raise your hand. And the noes, nay. And the nays prevailed. All right, that amendment fails. Just for the body's clarification, on the amendments, we'll just go with a simple majority, but for this bill to pass out of the committee, it's got to be the majority of both bodies individually. Okay, any other amendments or discussion?
Mr. Chairman, I have an amendment.
Senator Nethercutt.
Thank you. Page 4, line 13, after the word necessary, put a comma,
After necessary,
put a comma, but the court shall consider the fitness of the parent in making the determination.
okay? We're just adding at the end, but the court shall consider fitness. And a second. And so, whoops, go ahead, Senator Nethercutt, if you want to explain.
Yeah, Mr. Chairman, if I may, and just I would say a conforming amendment to add clarity to the bill in both places where this is addressed. So page 4, lines 3 through 10, as indicated on line 13. And then also on page 2, lines 1 through 5, that paragraph A, whereas on lines 2 through 3, the court shall consider the best interests of the child as well as the fitness of the parent. So add the language as well as the fitness of the parent after the word child, just to make it unequivocal and very clear that that is a required analysis by the court in making this determination.
Everybody clear how that's going to read on page 2?
Run that back.
Yep.
Repeat that again, please.
So reading lines 2 through 3, the court shall consider the best interests of the child as well as the fitness of the parent.
Okay, that's been moved and seconded as amendment. Question on the amendment, Representative Winters.
Thank you, Mr. Chairman. I guess I just didn't have a question then on page 4. When it comes back to that same lines 10 through 13, the court may consider the factors of subsection A of this section without first making a finding of parental fitness or a finding that the guardianship is no longer necessary, but the court shall consider the fitness of the parent. To me, it seems convoluted, like it's actually the is now combating itself, the paragraph. I'm just trying to understand what that would do.
Senator Nethercott.
Mr. Chairman, thank you. I welcome any friendly amendments to clarify that. But the purpose is that instead of it being a two-step process, if one then go to two, it's a combined analysis. So instead of saying one, fitness only, then two, because that's what the law currently states, and that's some of the challenges presented, the court also has to analyze that in making that determination for that guardianship. Constitutional interests still apply to the court. And this statute doesn't trump those constitutional rights. And I think that's important in understanding how this bill interplays with the Constitution, with the Wyoming and U.S. Supreme Court precedents, that this does not trump any of that.
Representative Winters.
Thank you, Mr. Chairman. And I suppose the question is for Ms. Nethercott then. So in that circumstance, what is the difference between striking the entirety of that subsection B as opposed to just adding a comma and then the new sentence, but the court shall consider the fitness of the parent? What's the difference between the two if we were to strike it all together as opposed to adding?
Before we go on, and you can think about that, Senator Nethercott, Brian, Torrey, I see you're pulling mics over by yourself and you're whispering. Do you have some advice on how we may bring the two or the joint amendment together?
Mr. Chairman, I wonder if it would be simpler to strike subsection B, or delete, excuse me.
Where you at? Page 4?
Page 4, delete lines 10 to 13 and replace it with a new subsection B that would read, in addition to considering the factors of subsection A of this section, the court shall determine the fitness of the parent in considering the petition.
I'd like to make that my motion.
Sounds like a friendly adjustment to your motion. Oh, okay.
Just adopt that one.
All right. So the motion, I hear that the bringer of the amendment is liking that. Could you go back, Tori O'Brien, and read then the amendment in both places on page 2 and page 4 as it's been presented with this tweak?
So, Mr. Chairman, the amendment, as I understand it, on page 2, line 3, after child, insert, and the fitness of the parent. Then page 4, lines 10 to 13, delete entirely and insert subsection B. In addition to considering the factors of subsection A of this section, the court shall determine the fitness of the parent and consider deciding the petition.
Questions on this adjusted language on the amendment? Representative Olson.
Mr. Chairman, I guess I don't think it's any more fair. I'm a little more confused. Because what this amendment does is direct the courts to consider both parental fitness and the best interest factors. Or could make what I will just call a wonky decision, which would be to find a parent fit, but then apply the best interest factors and make a totally different decision. So that it is a totally different thing to require the court to consider fitness than to require the court to find unfitness before proceeding forward. So I don't think that amendment is anything more than semantics. And if I'm wrong, I guess I would ask either for LSO or Senator Nethercott to correct me, but I think the result is still the same. I think right now the court can simply consider, this court already has to consider parental. It doesn't have to rest its decision on that conformity to the best interest analysis. And I think that's the question that this committee is actually resting.
Okay.
For clarification.
Representative Pelkey, you had your hands up?
Yeah, I just, in light of the changes that have been made, I just want.
Okay. All right. Okay. Would anyone like to address Representative Olson's question?
Mr. Chairman.
Senator Nethercott.
Yeah, if I may, I think again, and I know I've said this a number of times, but I think it's important to understand where this bill is in the process That's on the termination of a guardianship, right? And before an involuntary guardianship can be established, the court only looks at unfitness of the parent, and so that has been established. The court does not look at the best interest of the child at that point. It is only unfitness. If the court finds that the parent is fit in a petition for an involuntary guardianship, even if the parent is only marginally fit, the court cannot grant that guardianship. And so what this bill addresses is not that initiation of that guardianship, but at the end of it. So it contemplates after a period of time, typically years, that a child has been with a guardian, what that process looks like and what factors a court is to determine before a child's home is taken away, or it's the child's school. Before all of those things are taken away, the court is to look at, okay, this parent is coming back into this child's life. They're now in a different place than they were at the time this original involuntary guardianship was in place. But this child is also in a different place as well. And so the court needs to consider those factors as well of the impact that terminating this guardianship may have on this child. But that does not trump the child's rights, does not trump the parent's constitutional rights. Those are still preserved, and the court must take that into consideration. The court must follow the Constitution. And so what this does, though, is make sure that that requirement that the court does not overlook or obviate the need to establish and make very clear findings as to fitness as part of that analysis, but also doesn't ignore the fact, which is what the law currently does, that the fact that this child has been in someone else's care for a significant period of time.
So what I'd like to do is not to shut this discussion down. This is a great discussion. But before we go to the vote on the amendment, I'd like to invite the court to weigh in if they would like. And so just know that. But other questions or discussions on this amendment as it's been kind of redefined and cleared up by LSO?
Point of
Senator Kinski.
Yeah, just on against the amendment, I think it's a fine amendment insofar as it goes, but this whole bill, when we come to, it's just not ready for prime time. I don't see us kicking this thing out as a committee bill. It's too kludged together. I think the first 3 pages go way beyond.
We're still on the amendment, though.
I understand. I understand.
Okay.
It goes way beyond I think this amendment is still not going to fix the problem because the first 3 pages of the bill are still there. I think permissibly all we can do is a very narrow bill that says when a judge is faced with a parent who is or has been previously found unfit, that they can establish an integration plan, that they can order drug and alcohol testing, that they can order counseling, education, all towards helping to ascertain where this marginal parent is truly now fit. I think the last 2 pages of the bill are the only part that's salvageable.
All right.
So I'm on against the amendment.
Thank you.
Point of order.
Representative Stith.
Mr. Chairman, with respect to input from the judiciary, I think it's entirely appropriate and I'm really very appreciative that the members of the judiciary make the effort to be here and to advise us about things that we've done or that we might do that could make their lives more difficult or make the cases they have to handle unworkable. But I also believe in the separation of powers, and judges decide cases or controversies. They don't issue advisory opinions. So I don't think it's a good use of our time to ask judges if they think a particular bill is constitutional or if they think it's frankly good policy. That's just not what judges do. I think it's important for us to know how it might affect their lives or how it might affect their cases. As I think there's a distinction there. So that's my 2 cents on that.
Thank you. Any other discussion on the amendment?
Question on the amendment.
Okay, we've had the question called on the amendment. I would still invite the judges if they would like, since we're spending a fair amount of time talking about this, how this impacts or their read on it, on the amendment itself. If they would like to weigh in on the effect of the amendment. And thank you.
Morning, Mr. Chairman. Marv Tyler. I'm a 9th Judicial District Court judge out of Pinedale, Wyoming. I guess there's a couple of things I wanted to point out for consideration about this bill. First of all, this doesn't,
That's too much to do.
Judge Tyler,
this bill would, oh, I'm sorry.
are we going to be able to keep it on the amendment?
Yes.
Out of respect for,
Yeah, yes.
Thank you.
This bill is something that would be required on every termination of a guardianship involving a child, whether it's contested or not. And so is there a need on an uncontested termination to make these determinations about fitness and about best interests? That's the first thing I guess I'd say. The other thing is there is in Wyoming statute 3-2-101 A Romanet 5, which is the petition to establish a guardianship, facts in the petition to show that the best interests of the proposed ward requires appointment of a guardian. So there is a best interest that's required to set one up. And I think this best interest could be left just as it's described in that statute without all these factors, that the court shall consider those factors. Maybe the court may consider those factors to determine best interests of the ward and termination of a guardianship. Those are a couple of comments, I guess, that I believe touch on this amendment.
okay,
Thank you.
thank you. All right, the question's been called for the amendment. All those in favor of the amendment, say aye.
Aye.
Opposed? The amendment passes. All right, we're back on the bill. Further amendments? Any further amendments? Any further discussion on the bill before we go to a vote? You have a question? Yes,
Call the question.
call for the question. We are. And just a bit of clarity, in the beginning of the meeting, I said we were doing these bills and voting tomorrow. I was referring to the justice reinvestment bills. And so we are going to do a vote. And as a result, this will be a vote for each side, Senate vote and a House vote. And both sides have to carry the majority for it to go forward. And with that, do you have any questions of us at this time? Any from staff before we go to the vote? All right. How about roll call?
Mr. Chairman, this would be a vote for the committee to sponsor 19 LSO 26 version 0.5 as amended. Senator Anselmi Dalton.
Aye.
Senator Hicks.
Aye.
Senator Kinski.
No.
Senator Nethercott.
Aye.
Representative Beitman. Representative Jennings. Representative Olson. Representative Pelkey. Representative Pennell.
Aye.
Representative Salazar.
No.
Representative Stith.
No.
Representative Winters.
No.
Chairman Kirkbride.
Aye.
Chairman Christensen.
No.
Mr. Chairman, the vote in the Senate was 3 ayes, 2 noes. The vote for the House members, 3 ayes, 6 noes.
Okay. We didn't achieve a majority on both sides, so that bill will not move forward as a committee bill. Doesn't mean it won't be able to come forward as an individual bill, but it won't be come out of this as a joint sponsored committee bill. All right, let's take we can keep it short. We'll shoot for 5 minutes if that'll get the job done. A quick break. Thank you.
I'm trying to, I don't, yeah.
Children are chattel.
That paranoid.